My name is Ed Allcock, and with me today is my law partner, Ellen Shapiro. And we are going to talk today about the exciting world of condominium collections, mostly focused or centered on Massachusetts, but we will from time to time touch on places, other exotic states like Rhode Island, New Hampshire, Maine, and even Florida. In order to keep this exciting and interesting for all of our participants, we've put it together in a format kind of like, and maybe I'm dating myself, Casey Kasem's Top 40. We're going to do a musical sort of analogy for each topic and count down in reverse order, ultimately finishing with number one. I'd ask as we go along, if anybody wants to ask questions, put them in either the chat or the Q&A, and also feel free to identify the name of the artist of any of our questions. And for all participants who signed in and given me at least one artist name during the course of today's proceeding, I'm going to put you in a drawing for 2 Celtics tickets on Monday, November 13th against Oklahoma City. Yes, we are there now. Bruins and Celtics have pretty much started back up. So without further ado, we are going to begin our top 10 condo collection countdown.
I just want to make one comment. Ed and
Absolutely.
I are not singing. We are not going to be singing any of those. So don't get scared.
I might hum one here and there. So the place we start coming in at number 10 on the list is Champagne Supernova. And it's Champagne Supernova because we're talking about the eclipse that is the condominium super lien. And that really is the place to start. 21 states in the United States have some form of condominium super lien, some stronger than the other, most of which tend to be for a period of 6 months. I'd like to say, and I know that a lot of our Massachusetts brethren and even our friendly lawyers across the country tend to believe that Massachusetts may have possibly the strongest condominium super lien in the country. So what is a super lien? Why do they call it a super lien? I think the super lien really was born out of primarily, especially in Massachusetts and New England, the condominium crisis or depression caused by the recession, the recessed markets in the late 80s, early 90s. What people would find is that when property values went down and when bank foreclosures were at a high, people would stop paying their condo fees. You'd have at some complexes up to half of the people in the complex not paying their condo fees. Banks would foreclose. And what wound up happening is you'd have, a quarter or 50% of the people paying or trying to pay for the services for 100% of the units. There was no certainty. It actually wound up driving prices in the condominium market down farther. I mean, I remember as a young lawyer in the 90s, early 90s, people talking about buying condominium units in Boston for, 2 figures, $40,000, $50,000 units. If you can imagine that in the city. The super lien came about, and it was a negotiated compromise between lenders and condominium lobby that allowed the lien for condominium payment of common expenses to jump over the first mortgage on a unit for a limited period of time. Let's say it's 6 months. And what that does is it provides staying power to the condominiums. It prevents that erosion of value when you have a recession or sort of a foreclosure crisis. It allows the condominium to recoup and have a lien to allow it to recoup common expenses, even in the face of an owner not paying. And we all know that if they stop paying their condo fees, the owner's likely not paying their mortgage. What does it ultimately do? I mean, sometimes it ultimately results in the lender paying common expenses directly because the owner doesn't pay the common expenses, and then ultimately the lender charging those expenses back to the owner, to the person that borrowed the funds to buy the unit in the first place. Like I said, Massachusetts is 6 months. All of most of the New England states that have it, Rhode Island, New Hampshire, Maine. Maine doesn't have one. They're all 6 months. Florida is 6 months. Unfortunately, Maine has not yet convinced the lender lobby to pass a super lien, so they're a little bit behind the curve statewide and New England wide. And like I said, the point of item number 10 on our countdown is so that everybody kind of understands this is the process. This is what the law provides. And quite frankly, we're lucky to be one of those, or at least some of our New England states are lucky to be included within the 21. Massachusetts is probably the strongest. I'd say if anybody here from Rhode Island is not, Rhode Island's pretty good, but they have some limitations in terms of costs and attorney's fees. New Hampshire, 6 months as well, but they have some issues in terms of remedies. They don't really have a foreclosure remedy. And the real takeaway, the real strength of the super lien is if your lien is first and you get to a foreclosure, it allows you to wipe out at a foreclosure sale anybody that is junior. So there's real power inherent in that super lien when it comes to your relationship with the lender, which is oftentimes why the lender winds up stepping up and paying the delinquent expenses so that they can protect their mortgage. Ellen, anything else that we would have on Champagne Supernova, on the super lien that you want to add?
The only thing that I would add is that a slight problem in Rhode Island is the right of redemption when they do a foreclosure, which makes it a little bit trickier in Rhode Island, but still very successful in Rhode Island.
Yeah, so obviously in Massachusetts, in Massachusetts, it's judicial foreclosure. Rhode Island, it's non-judicial. In Massachusetts, you get it to if it goes all the way, you get it to a foreclosure. There's an auction, and then ultimately there's a sale. Same process in Rhode Island, except that there is a opportunity for the lender that wasn't paying attention during the foreclosure process to step in and redeem. Now, the lender, in order to redeem in Rhode Island, has to pay the full amount that is due and owing, not just the priority. and I know Ellen's going to want to talk about priority when we get to our next slide, which is the
Great.
process, right?
Right. Good lead in. Thank you.
Number 9 on our list, take the money and run.
Our priority lien is, as Ed has already mentioned, a judicial process. That means, unlike a mortgage, we have to go to court and have a judge give his or her blessing on the right that we have to sell the unit. And we actually get a judgment for the money and an order to sell the unit to satisfy the money. It's a 6-month period, and it relates back from the date the complaint is filed. And we'll get to that later when you say, well, what happens after the complaint is filed? But we will show you that you can get that as well. This is called a rolling lien in Massachusetts because as a result of the case of Drummer Boy versus Britain, which went on forever, even though the decision we're talking about was in 2016, it was recognized that we can, in fact, file a complaint every 6 months and roll the lien forward in that fashion. Prior to that decision, we always believed it and we always argued that you could, but the court finally got around to recognizing that we were right. Now, what do you actually do to do this? Because this is a process. And if you miss a step, it may not be fatal, but it's really not a good idea. The first thing, of course, is the notice of delinquency to the unit owner. You always have to let the unit owner know that the money is owed. After that, the lender receives the notice of the unit owner's delinquency. And then the lender gets a notice that the association intends to file suit. And after all of that is done, and you're at the 6-month mark, you file the complaint. Now, what's the best time to start sending these letters? The magic time is 60, when the unit owner is 60 days in arrears. That starts the clock running. And 60 days doesn't mean 2 months. A lot of people say when the owner owes 2 months. It's not 2 months. You might have posted January and February, but that owner is not 60 days in arrears. So it's important to recognize that because sometimes associations get a little confused. And then you have the issue of February being 28 days. So you have to be mindful of that as well. We recommend when the account is 60 days in arrears that the statutory notice of delinquency go to the owner. Some associations, some management companies like to give the owner a little more time. That's fine, as long as you keep your eye on the clock. And you can wait until 90 days. That's not going to really slow the process down that much. The notice of delinquency that goes to the lender should be sent no later than 4 or 5 months. I like to do it in stages if we have the luxury that we've got an account at the very beginning of the process. In that fashion, you get a little bit at a time. And because I do so much in court, I find judges look more favorably at that you say, Your Honor, he had plenty of notice, he had plenty of time before these legal fees started accruing. But sometimes it happens, it falls through the cracks, people are busy, management's busy, and the account can be really at the 6-month mark by the time it lands on our desk. Again, not fatal. We do it all at once and do the same process, but they're all sent within a very short time period. The important thing is to get the complaint on file before 6 months has passed. That's really the most important part.
And Ellen, the reason for talking about the importance of getting things out, whether it's in 60, 90, and then 6 months, is the idea that we don't lose any portion of the priority if the matter progresses to a contest either with the lender or the owner, right?
Well, yes and no. Well, we never lose it if it's properly done.
Correct.
If you don't do it properly, you can lose a portion. But that's why I say 6 months is your magic date. As long as you have that complaint filed unrecorded, you should be protected. And things happen, things fall through the cracks. We all know it. But as a general rule, 6 months is your optimum time. what is particularly important to note, though, and this is really, I believe, all the states that have priority liens, no special assessments, no fines, and no late fees are included.
But it does include attorney's fees and collection costs, right?
Well, that's what I was getting to before you so rudely interrupted me. Yes, it does include attorney's fees and collection costs, which of course we all know is the most important. But it's really funny because sometimes, and it's not our fault, it's the unit owner's fault, those can be more than the debt that's owed. The work is the same if the common fee is $75 a month or $750 a month. We have to do the same amount of work. So that's sort of an interesting issue that it's not as bad now, but when the super lien first started, judges really struggled with that. When we talk about the Prince case later on, that was really one of the underpinnings of that case because the amount that was owed was so minimal in relation to the value of the condominium. So now you're saying you had short amounts of condo fees, you had the legal fees, and the condo is worth, umpteen amount. But I'm getting ahead of myself, as always. And the important thing is at 60 days, flag it. If you make a conscious decision to wait another month, that's okay, as long as you have flagged it and start the clock there. Everybody on this Zoom probably knows what their constituency is like. And some associations know, some managers know that if this person gets the letter at 60 days, they're going to pay it right away. So you really have to know how your unit owners are. Everybody has a different way of handling it, but everybody has to get their complaint filed and recorded at 6 months. After that, I'm going to tell you, clever little tagline, don't delay or you will pay. Well, I don't think we're going to expect you to pay particularly, but it will hurt the bottom line. And on that, I am going to go into more discussion about the priority lien rolling.
Before you do that, Ellen, there was a question.
I'm sorry.
There was a question. Somebody asked if there's no priority that attaches to fines or late fees, then why bother assessing fines or late fees?
Well, at the end of our Zoom, there's going to be mention of the 6D or resale certificate, as it's called in other states. And that is an extremely powerful tool. And it may not be great for the boards when the unit owner's account is showing all these fines and late fees, because you're saying, oh, boy, he's carrying all this. But everybody dies or sells. And in order to sell, not in order to die, but in order to sell, you have to have a 6D certificate, and it needs to be what we call clean, showing that no common fees are owed, no fines, no late fees, no attorney's fees. If the 6D is a dirty 6D and shows $4,000 in fines, you get that money because lenders want to see a clean 6D. So down the road, you will get it, and the owner is going to have to pay it. It will come back to haunt him that he allowed those fines or late fees to accrue. You will get your money then, but that's the trade-off in the super lien. You get the bulk of the money. And don't forget, fines and late fees, they're not part of your budget. They're what I call the frosting on the cake. You get the cake. You may have to wait later for the frosting, but you will get it ultimately.
And fines can have a effect, an enforcement purpose or an effect. And you might even wind up with a unit that does not have a mortgage or a high mortgage.
If you have a unit that has, well, that's interesting because we didn't discuss that when we were preparing for this. You might have a unit that has a low mortgage. The mortgage has been out for 25 years, so there's very little left on it. You can still do what we call a non-priority lien, non-priority foreclosure. Same process, just you have to pay you have to be aware of the fact that the first mortgage is hanging out there. And it still is an attractive purchase for many purchasers who do their due diligence. They figure out, they go to the registry, they look at the mortgage. Oh, this mortgage is 25 years old, probably very little left on it. So they will buy it with that mortgage because it's a non-priority lien, and then they'll pay off the mortgage. So they still get a bargain on that. That doesn't happen quite as often as we might wish, but it still is a remedy that's available. And that's why it's so important. When I talk about the 4 things you have to do, notice of delinquency, et cetera, and so forth, included in there is other work. We order the title and review the title, and that information comes from review of the title. That's when you can sort of do the rough equation in your minds as to whether or not the unit has equity, which could be used to pay off your non-priority amounts. So thank you for reminding me of that, Ed.
Yeah, I mean that's really the whole point of the priority lien. The whole reason it was enacted is to cover deficiencies in equity, or when the unit would otherwise be upside down with the lender. So, all right, Ellen, I'm going to take you to the next slide. And I think you've already alluded to this.
Yep.
I think we're gonna roll with it. Talk about the mass rolling lien.
Okay. I mentioned Drummer Boy before. That's the one that established, absolutely no doubt about it, you can file successive 6-month liens. Now, why is that important? Somebody was asking about that earlier, I believe. Well, you filed your complaint at 6 months. That's great, but we're a judicial state. So that means you have to go through a lawsuit. That's really what it means, a complaint, an answer, various pleadings, various documents, and every now and then we get into a contested case where either the bank contests it and says they didn't get proper notice, the bank contests it and says, oh, this is really a disguised special assessment. The unit owner does all sorts of crazy things, which ties the case up in court forever. So this is the beauty of the rolling lien. As we're litigating the first case, we start a second action. We roll that lien forward to capture the months that were tied up in court. And with the second lien, when you roll it forward, there's no diminution in the potential judgment and order. You get the legal fees on the second action. If you have to go to a third action, same thing. The court doesn't say, oh, you're not entitled to them because you were doing one action. The court could say it. I mean, we every now and then hit judges who get a little stubborn, but at the end of the day, you're entitled to the same thing if you do 1, 2, or 3 liens and roll it forward, because it's not fair. The reason you're doing all these other complaints is somebody along the line mucked up the system. They stopped you from going forward. So if you pay attention carefully, you should not miss any months. And that is really incredibly important. So even when I send a payoff check to a client, I'll put a note in, this pays through October of 2022. Please notify me when the unit is 60 days in arrears again. So we give a little tickle to you to mark that and keep an eye on it, because there are a lot of people who are what I call frequent flyers, and they go through this process all the time. Now, there's something I want to clean up. The lien in Massachusetts exists the minute the master deed is recorded. And I get calls from people all the time saying, you placed a lien on my unit. No, I don't bother explaining it to irate unit owners because there's no sense in it. But I'd like you folks to go away understanding this. The minute that master deed is on record, that lien is there. What we do by the filing and recording of the lawsuit and the complaint, we perfect the lien. And unless you perfect a lien, you can't enforce it by selling. You can't get the judgment in order of sale. Can you get the money? Oh yeah, lenders send us the money all the time without our going to lawsuit. They know, they've wised up, they know what's going to happen. But the lien exists automatically. We're just enforcers. Think of us as your long arm of enforcement. That's what we do.
And to me, Ellen, the takeaway on the mass rolling lien is that sometimes you need it because Massachusetts is a judicial foreclosure process.
Right.
And it's not as easy to get through court in 6 to 12 months. By contrast, in Rhode Island, it's a non-judicial foreclosure. So, you're setting up you're sending out the notices, you're setting up the dates with the auctioneer within that you'll always be done, or you should be done within that 6-month time frame. Otherwise, you'll lose a month or two.
Yeah, we don't have that luxury here, and that's why typically, if we do a foreclosure, we record another complaint. We do another process right before the foreclosure sales, so that we perfected it up. Let's say your foreclosure is 4 months after your first complaint went on. We put another complaint on record, just to make sure that everybody understands what's happening here. And in fairness, this has been here for a while. Most of the lenders are very much aware of it, and they understand, they understand what happened. We even have cases where lenders have called us after the foreclosure and said, oops, just got your notice. And we say, oh, well, that's now a different issue between you and the buyer, but it happens. So it's not a perfect world, but if you follow it properly, this is as close to a perfect system as you're going to have to collect those fees. Now, because this next slide is about the midnight special and the not so special assessment, we're going to give it to our special man of the hour and give it to Ed. I thought that was cute.
So the real issue here, and it happens countless times with community associations, there's a problem. It could be a lawsuit. It could be a construction issue. It could be just inflation. All of a sudden, it's the middle of the year and the condo needs money. And what the condo does, and they do it more frequently than I'd like to see, is I say, all right, well, we got a huge budget shortfall. We need to issue a special assessment. Everybody's getting a bill for $5,000. It's payable in 30 days, or it's payable in 3 installments over 90 days, whatever it is. The problem when it comes to condominium collections is that the super lien will not attach to special assessments. So if the owner doesn't pay the special assessment, it's difficult from a priority perspective. Again, priority, if there's issues, if there's not a lot of equity in that unit, it's difficult to collect that special assessment via the super lien. So, and in fact, there is no state, none of the 21 states afford super lien priority to the collection of special assessments. So what is an association to do? I tell them all the time. I know Ellen tells them all the time. Sometimes they listen, sometimes they don't. The best way is when you see that there's a budget shortfall and you need to collect the money to clean up your budget shortfall at the end of the year, is to go back and amend your budget to incorporate the assessment into the monthly condo fee, so that if there's a non-payment issue, you're not going to have any issue. You're not going to have any issue collecting it, if need be, via via a collection process and including it within the priority lien. I've seen some associations identify it as a supplemental assessment. I mean, I don't know. To me, if it looks like a duck and it walks like a duck, it's a duck. But if you're going to adopt and call it a supplemental assessment, I would make it formal. I would use that language. I would put it in the meeting minutes. We have had the occasional scenario where there's a priority lien collection and the lender wants to go back and look at the meeting minutes to see how it was handled, how it was adopted, what it really is. To me, it's don't just call it by another name. Go back, amend your budget, because the priority lien attaches to the amount of the monthly budgeted common expenses. That's in every super lien condominium provision in all 21 states. It's the monthly budgeted amount. And if you think about it, that's fair, right? The lender doesn't want to say, oh, you just issued a $40,000 special assessment, and now your $40,000 special assessment is going to jump over the mortgage. No, that's not what they signed up for. That's not part of the negotiated back and forth. Now, I have already seen a question come in. Well, okay, counsel, what do we do? What do we do if we need $100,000 quickly, or if we need $1 million quickly, or 2 million? What do we do? We need this money quickly to go fix something. Well, you can do the special assessment, but the warning that you're getting from us is if it goes bad and people don't pay it, you might run into issues with the priority. Now, probably the real answer is explore getting an association loan. And when you get your association loan, you'll get the money up front, and then the lender will have you build the repayment of that loan into the budget so that you don't run into the priority issue. So that's why I call it, beware of the midnight special and the not so special assessment when it comes to possibly having to collect that. Ellen, anything on the special assessment you'd like to add?
Nope, I think you summed it up perfectly.
All right, well, going from special assessment, how about bankruptcy?
No.
I need $1. That's the name of this. That's the name of hit number 6 on the countdown. I need $1 when a unit owner files bankruptcy. Ellen, what do we do?
Well, the first thing you do is don't ignore it. Again, if followed properly, you can still collect all your money, but you have to be aware of some potential traps. When you get a notice of bankruptcy, you completely stop what you're doing. You can't pursue a unit owner who has filed for bankruptcy. You can't chase them for debt, particularly debt that was existing before the bankruptcy. There's what's called an automatic stay. You have to stop going forward, and there are penalties for violating that. But there is relief from the automatic stay, and it's called a motion for relief, oddly enough. So you have to file a formal motion setting forth the reasons why you should not be barred from going forward to collect this money. There are 2 types of bankruptcy proceedings. I'm just going to mention them briefly because it's beyond the scope of this webinar. I still call them seminars. There's a Chapter 7, which is a liquidation. The debtor is getting rid of all of his assets to pay off whatever he can, 10 cents on the dollar or nothing on the dollar. And he's going to emerge from bankruptcy without any assets, virtually, and without any debt. That personal debt's cleared off, everything. Chapter 13, which is really interesting because that's called a reorganization, that the debtor files a plan. And it's important to split your ledger into pre and post petition bankruptcy. It's critically important because, as I said, you can't go after the debtor for pre-petition fees without relief from the automatic stay. Now, if the debtor is going to be getting rid of all his assets in a Chapter 7, you might say, well, what's the point of getting relief from the stay? He's getting rid of this place. That's not true. We still have our priority lien. The beauty of our priority lien, because it is what is known as a statutory lien, it passes through bankruptcy. The debtor doesn't have to pay it, but by a wonderful piece of legal fiction, the unit has to pay it. How does the unit pay it? We go through a foreclosure process, and that's as though the unit owner hadn't filed for bankruptcy. It's exactly the same process, but you must get relief prior to doing anything. Now, the chapter 13 is interesting because the debtor is given an opportunity to take his or her debts. They categorize them secured, unsecured, et cetera, and so forth. We're secured because it's a lien on the real estate. And he gets to put that money into a plan. It is very, very important that you examine the plan. Debtors frequently list our lien as unsecured. They list it incorrectly. They don't put the right amount in because they didn't calculate it. They're using an old ledger. So you have to really examine that because you want to notify the court that, no, this plan's not going to work. My debt has not been scheduled properly. So once you get through all that and assume your debt is finally scheduled properly, then you have to examine it for the period of time for the payout. Bankruptcy court allows debtors up to 5 years to pay off their arrearage. So if you think it's bad waiting around for the debtor to sell, for someone to sell, to collect on the 6D, just imagine waiting around 5 years to get it. And you get these little checks and dribs and drabs from the trustee in bankruptcy. And I can hear the managers groaning because it's a nightmare. And for accounting, I get it. There's nothing we can do about it. That's simply the way it is. The trustee waits till he or she accumulates money and then disperses it in accordance with the plan. And you sit around and wait for 5 years. But at least during those 5 years, the debtor has to pay promptly going forward. And if the debtor doesn't, and that unit account falls into arrears, at this point, I say 3 months because bankruptcy doesn't get excited about a debtor being 60 days out. So when you get that 3 months or 90 days, then you file a motion for relief saying, hey, this isn't fair. You know, you can't have it both ways, trying to pay out the debt over 5 years and now accumulating more debt, not part of the plan and still not paying, but living there. So there are remedies and they're very interesting. I happen to like this part of the practice very much. What else did I want to say to you? The fact that the lien passes through bankruptcy is extremely important because a lot of times if you have the dreaded special assessment, that doesn't get discharged either. So in that case, it's not a priority lien, but the debtor couldn't get rid of it. So
It's still a lien. It's still a lien. It's just not priority.
They just, you know, we can't make the priority argument, but it's still a lien. And quite often that kind of gets the debtor in line to pay. Many times debtors think that they can pay, that they can file for bankruptcy to get out of a special assessment, but that's not the way it works. So if you pay attention to it, again, this is technical. You know, the other part may look fairly procedural and cut and dry. This is technical. A misstep can have serious consequences because again, this is beyond the scope of this webinar, but you have to file a proof of claim. There are things you need to do in order to protect yourself, particularly in the 13. You have, like I said, you have to examine that plan. You have to file a proof of claim. You have to see that your proof of claim is accepted. There are deadlines, times when you can object. So it's very technical, procedural, but followed properly, you'll be in great shape. I assure you of that. So having said that, when you get that notice that a unit owner is filed for bankruptcy, don't just stick it in the file. And don't say, oh, well, there's nothing we can do. Now he's in bankruptcy, we're cooked. No, that's absolutely not true. Done properly, you'll be in great shape.
And to me, probably the most important takeaway on bankruptcy that everybody needs to understand is that when an owner files bankruptcy, that automatic stay, it's effectively an automatic court injunction, and you are not allowed to continue collection activity after you get the notice of the bankruptcy. If you do, you're violating a court order. There could be fines or penalties. So, and like Ellen said, she's talking about 7s, 13s. Bankruptcy is so specialized. As soon as you get notice of an owner bankruptcy, when that owner is delinquent, you really should consult with counsel.
Not to scare you, but when you talk about violations, bankruptcy is under the supervision of the Department of Justice. So it's really pretty serious if you violate the stay. So not to scare you, but you have to understand that it's great. It's not like, I mean, violating court order is bad enough at any time, but this one is really bad. So with that, Ed, do you want to talk about how it's fine to fine?
Oh, absolutely. I want to break free, right? When we talk about fines and unit owner misconduct, we're talking about unit owners saying, look, I want to break free. I don't want to be part of this condo. I want to be able to do whatever I want. Most statutes, all the New England states, they allow, and most of our documents allow for fining when an owner doesn't comply with the rules, regulations. They also have usually misconduct assessments, and I've seen a few people on the chat asking about charging things back to the owners, things that they've caused the association, like they failed to repair the skylight and the association had to do it, or, you know, they drove their car into the clubhouse or into the, I remember seeing a lot, the automatic garage doors, they take the whole thing down by accident. Is that misconduct? Can they, those are the things that can be charged back to an owner, and the lien attaches to that. The process for collecting it is the same as your regular condo fees. The problem is, as we've kind of already hinted at, the priority does not attach to fines or misconduct. That being said, and it really depends on the case. In my experience, and I've litigated several condominium fine or misconduct cases in Massachusetts, Rhode Island, and New Hampshire, is that courts don't love fine cases. And a lot of times the ones where I was litigating them, we're talking about $500 a day fines or big misconduct assessments where when you're in court, you're talking about 20s to hundreds of thousands of dollars. And I've got like 3 examples. There was the Clarendon Warren versus Cotto case, where we had an owner that was purposely feeding the pigeons on the condominium, on the sidewalk in the south end of Boston. He was dumping 100-pound bags of birdseed. And why was he doing that? Was he really trying to feed the pigeons? That's what he claimed, but it was underneath the president of the board's first floor unit. And when you dump a 100-pound bag of birdseed underneath someone's window, it wound up being a rodent rat infestation problem. So they fined this individual. He fought it tooth and nail. We got to Superior Court. I think the association was awarded upwards of $150,000 in fines and legal fees. And then we got to the appeals court. The individual wound up getting legal aid to handle his case at the appeals court, and the appeals court took it all away. The appeals court said, well, the misconduct that was occurring there was occurring on the public sidewalk. It wasn't occurring within the borders of the condominium association itself. So we're going to hold that conduct is not finable because it was occurring outside the borders of the condominium. They found a loophole. And that's one of the takeaways. Whenever you're going to go to court, you got to understand that sometimes you're at the law might say one thing, it might make common sense to you and I, especially if we live in an association, but sometimes judges, they just don't feel it's right. I remember at that appellate court argument, the judge said, well, counsel, this is on the sidewalk. What do you care? I said, well, let me give you a hypothetical, Your Honor. What if somebody drove a van with explosives in it and parked it next to the association and they blew up the condominium building? Would that be misconduct? And the judge said, well, that's not the same thing. That's not the same thing as feeding the pigeon. So you got to understand when you go to court on some of these cases, it can be, you're at the whims of the judge. Now, Hunter's Village, Gerke, that was another one. There was a property manager that lived in the condominium. She also happened to be a unit owner. So she was a unit owner, property manager, and a trustee. The allegations were that she embezzled some money. So the thought was, well, that's misconduct. We're assessing your unit $70,000. The court ultimately, and it was appellate level, said, wait a minute, she didn't steal the money as a unit owner, so it's not unit owner misconduct. She stole the money, and the only reason she had access to the money was a property manager. You can't assess her a fine or misconduct and put a lien on a unit. You have to go after her for as a property manager. The last fine case that I'll talk about, and this is a fun one, both Ellen and I were involved in this when this was Thomas Graves versus Gargano. Thomas Graves, this was a condominium in Cambridge where a lawyer actually tapped into the gas line for the association to heat his law office. And the association didn't discover it for several years. They were wondering why their gas bill was so big, their common area gas bill. And we ultimately went back, did some forensic math, figured out it was like $60,000 of gas that he had stole from the owners to heat his law office, if you can believe that. And then we asked him for it. He said, I'm not paying you that back. We started fining him, went to court and had a trial. And the judge gave a great award to the association that then wound its way through the appellate courts. At every step on the way, none of the judges liked the attorney stealing gas. So it's funny sometimes. It's just what are the facts? Attorney stealing gas, judges don't like it. Poor owner feeding pigeons, different story. So sometimes on these fine cases, they can get out of hand, they can become expensive, and then you're at the whims of whether the judge likes the optics. And so what Ellen and I recommend is if you really want to find somebody or say that they've engaged in misconduct, the state of Rhode Island, actually in this instance, I think is ahead of Massachusetts and the other New England states. In order to proceed with a fine case in Rhode Island, you need to have what's called a due process hearing. So in other words, you bring the unit owner in, you give him an opportunity to show up at a meeting and explain what he's doing, why he shouldn't be fined. Sometimes the association counsel, I've presided over some of these, is there. You always want to let the other side know if counsel's going to be there, they can bring their counsel. And what I find happens sometimes at these due process hearings is the parties hear each other. They understand each other. They can understand where the other's coming from. And sometimes it can get worked out at those hearings. Now, at other times, it can get a little out of hand and people get heated. But in my view, actually sitting down and talking with somebody, and especially if other counsel is there or both counsel are there, I find that it can lead to resolution rather than one of these cases that goes on for years in Superior Court and then appellate court. What do you think, Ellen?
One observation there on that. Just keep in mind, the purpose of fines is to bring somebody into compliance. Fines are not to supplement the association budget. And if you see someone is ignoring the fines, ignoring your warning letters, maybe even ignoring a request to come to a due process hearing, and still is violating the documents, being engaging in misconduct, then you have to think about what are we doing? What are we accomplishing? And that's when you really have to start considering going to court and suing him, trying to get an injunction against that behavior. Keep in mind that misconduct means that the judge has the power to award attorney's fees and costs to you. Unlike the super lien where it's automatic, the judge has discretion. And a lot of judges will say, you got what you wanted, counselor. The unit owner's in compliance now. He's fixed that leak or whatever. And I'm not going to give you attorney's fees too. But you have to think about the purpose of your fines and not just do them, for the sake of running up a big fine and everybody's ignoring it anyway. And the unit owner is saying, I'll worry about it when I sell. I had one association where it had no dogs were allowed, and the unit owner was being fined every day. And the fine was like $5 a day. And he said, hey, for $150 for my dog, I'll pay the fine every day of the week. So that's what happened. Somebody asked about how you determine the amount of fines. I have a theory. It has to be rationally related to the offense. If someone is littering, you're not going to charge $500. If someone is smoking on the deck and running the risk of fire, $500. So you have to kind of weigh the offense with the severity of the consequences should the bad behavior continue.
I remember in one of these cases, I can't remember which one it was. It might have been Cotto. One of the arguments that was being made by opposing counsel was that the association did not have a fine schedule identified in their documents. Do you think that's a good idea, Ellen, to have associations?
In all the years I've been doing this, I've gone back and forth on it, because every now and then you get something that doesn't fit neatly into that bucket, and then you're in trouble. I think that what is better is a policy of first time it's a warning, second time call you in for a hearing, third time a fine in the discretion of the board. I've been doing this long enough that I find that boards are pretty reasonable. They understand the concept, especially if the lawyer's involved. We explain it to them and they've been doing a good job of it. It's very hard to limit yourself to the exact amount of this fine is for this. But if you're going to do that, set up categories, make sure that of the severity of the offense, if it's going to cause injury to somebody, if it's merely cosmetic, that kind of thing, at least categorize it. Because I don't think courts like a one size fits all. I really don't.
What I can't believe is that nobody was able to identify the artist for the song "I Want to Break Free." So, but that we're going to move on to something a little harder musically. Bleed It Out. And Ellen, can you tell us about Blood and Prince?
Okay, I'm going to move along quickly because I see we're running out of time.
Oh, we got plenty of time.
Okay, we've got plenty of time.
Plenty of time.
Okay, all right, we're not running out of time. I'll talk slowly. The two early cases in Massachusetts that really brought this to a head are Blood versus Edgar and Prince versus Prosser. And they said, hey, this is not a landlord-tenant situation. These people need this money to run this building. You cannot withhold your common fees. And they likened it to a municipality or the government. You have to pay your taxes. You can protest afterwards, but you must pay them under protest. And basically slammed the door on the ability of a unit owner to say, I'm not paying because the carpet isn't clean or whatever. The statute basically says that there's no right to withhold, but it was always nice to have a court agree with the statute because a lot of times they don't. The court articulated the remedy for the unit owner: pay under protest. That doesn't mean hold it in escrow. We get letters all the time. I'm escrowing my money. Here's a copy of the bank account. We don't care. Pay us the money. Now, the theory behind these cases is it's the truth. This is the association's only source of income. If you live in a single family home, you can't ask your next door neighbor to pay your insurance. Doesn't work that way. Without common fees, associations can't function. This is how the whole super lien started, because associations can't function without the funds. The theory of being unfair to the other owners, it's interesting because when this first started, and we would say that to judges, they sort of, they didn't get that worked up and excited about it. But now that we've been doing this for a number of years, we understand, counselor, you don't want the other unit owners paying, which is true. And I have seen almost no judge ignore Blood and Prince. What I have seen in one instance was a judge disagreeing with the theory of go to court to have it declared illegal. There is the catch that if it's illegal, that's a different story. A prior determination of illegality can buy a unit owner some lead time. But courts, the one case that I know of, judge was not happy that this is not illegal because we don't exactly, they never said what's illegal. The board has the power to assess legal to common fees. So what's illegal about it? Unless they were doing it to buy somebody a fur coat. It's really hard to get your head around what would be illegal. And I've never seen a set of documents where the board doesn't have the authority to set the budget and get the unit owners to pay it. So that's hanging out there for another day, but that's the one cop-out that a unit owner would have. Plus, not many unit owners are willing to pay the money to file a lawsuit to say it's illegal to assess the common fee when the common fee was far less than what it would cost them to get that far. So don't dispute the takeaway is that don't let the unit owner dispute it. They have to pay to play. That's the basic theory. And it's correct in many situations, but particularly in common fee payment.
A lot of the owners and some of their lawyers don't understand because in the rental world, in the apartment world,
right,
when there's an issue with your apartment, tenants are often allowed to withhold rent to compel the landlord to actually, fix the leak or whatever the issue is. And so oftentimes, and I hate it when it happens, and I know Ellen does too, oftentimes owners or their lawyers confuse apartments with condominiums, and we all know that they're not the same.
And what's worse is when judges do. That's even worse when they do.
It happens from time to time, but that's why we're here. We educate the judges as well. So
and they take so kindly to it.
Well, we try to do it in a nice way. So we're down to number 3 on the countdown, and that is fight the power. So the takeaway on this is there is an act. There's a federal act. It's called the Fair Debt Collection Practices Act. It's usually not something that associations can run afoul of. It applies to businesses that are collecting debts as part of their business. So it applies to Ellen and I, in theory. And it's a very, very, very complex piece of federal legislation. And in fact, there was a recent amendment to the regulations prompted by one of our state senators that I think what is it called? Regulation X. It goes on for like 900 pages. It's very, very dense in terms of rules and tricks and traps. So the first thing I want to talk about is can a property manager run afoul of it? Yes, theoretically they can, but the case law across the country indicates that if the property manager is involved in the collection of HOA fees or common expenses as an ancillary part of their primary duty, if it's part of their fiduciary duty that they owe as a property manager, part of their contractual duty, but it's not the primary duty to the association, then they will not be considered a debt collector under the act. So what should property managers do in order to possibly avoid exposure under the Federal Fair Debt Collection Practices Act? Is they should make sure that in their contracts with condominium associations, they spell out all of their duties, or specifically spell out that collection of condo fees is ancillary to their primary agency relationship with the association. And there are, like I said, several cases across the country that interpret it in that fashion. So as I said, lawyers can certainly be liable for FDCPA violations. There are 2 major Massachusetts condominium collection cases in the federal court system, one all the way to the First Circuit Court of Appeals. that have held law firms liable for condominium collection cases. And they're interesting. It's stuff where, the wrong suit was filed in the wrong county, even though the county was allowable to be filed in under the venue statutes. The FDCPA says it has to be filed in the place that's closest to the owner. And then there are other issues in terms of certain tacking on a number of unposted legal fees and handwriting, attempting to collect exorbitant interest, things of that nature. However, there is some emerging case law when it comes to FDCPA, and it's kind of interesting. It comes out of two cases out of the United States Supreme Court that talk about secured debt not being subject to the FDCPA. Now, that secured debt case was the Obdusky case, and that dealt with non-judicial foreclosure. And we've already talked about in Massachusetts that we utilize judicial foreclosure. Now, in my opinion, if collection of secured debt, i.e. debt that has a lien that attaches to it, is not subject, if it's non-judicial, it should not be subject if it's judicial, because judicial foreclosure is more protective to the consumer or the debtor than non-judicial. But we've seen some reluctance across the various circuits to adopt that, again, because the judges want to protect the debtors. But the First Circuit has a judge in the district court in our circuit has recently indicated she thinks it applies to judicial foreclosure, which is great news. The second more interesting issue from the United States Supreme Court is, if you understand the way the FDCPA works, is there's all these little technical violations. And if you engage in a technical violation of the act, even if there's no harm to the debtor, like you send them the wrong worded notice, or you file it in the wrong court. There's all of these technical things. You call him after 7:30 at night, but he answers the phone and talks to you. Is that a technical violation? Under the act, a technical violation is a minimum of $1,000 or a maximum of $1,000 per violation, plus attorney's fees. And then there's opportunity for class actions and all kinds of things like that. But what the Supreme Court has recently said in the TransUnion case, and then some of the circuits have kind of jumped on that in terms of condo fee collection, HOA fee collection. What they've held is, in order to bring a claim under the FDCPA, you have to allege actual harm. There has to be something more than just simply a technical statutory violation. You have to have suffered some sort of physical, personal, emotional, reputational harm as a result of that statutory violation. So I actually think those are decent trends in the FDCPA world, to the extent they would even apply to a manager or a law firm attempting to collect these debts. I think the takeaways here are, you have to be aware of the federal overlay and some of these consumer debt protection laws. We have certain senators that really push that, especially in this state. Got to be aware of it. I think from a property manager standpoint, you want to manage your contracts so that you don't, so that you keep yourself out of the realm as a quote unquote debt collector. And quite frankly, I think whether you're an attorney or whether you are a property manager, you might want to think about insurance that would protect you from one of these claims. Like I said, there are certain lawyers who are out there looking for these technical statutory violations, the so-called class action lawyers. We see it all the time on the news or late night TV, people looking for these class actions. Certain insurance companies will actually sell either a management company or a law firm something called an FDCPA rider that will protect you in the event of what ultimately can be very lengthy and aggressive contests over small dollars. So that's my takeaway on the FDCPA. The law is emerging on that at the Supreme Court, and I know we're going to have an opportunity to discuss that. That could be its own topic, and it's going to be a subject of future newsletters. Ellen, anything you have on the FDCPA?
I just want to say that somehow people, when they talk about FDCPA violations, the courts were losing sight of the fact these people really owe the money. You know, it's one thing if you didn't owe the money and you're being pursued. Okay, I understand that. And you show proof and you show canceled checks and you're still being hounded. Got it. But when you're talking about people who owed the money to allow wiggle room because a letter was sent to the wrong post office box or the case was filed in the wrong district court, it's one of those times that the law makes absolutely no sense. And it's great to see the circuit courts waking up and saying, oh, that's what you're talking about. Yeah, it was no harm, no foul. So it's a trend. Hopefully it's going to gather some momentum, and stay tuned. We'll keep you posted.
All right, Ellen, we're down to number 2 on our list. Hey
Moving
ho,
on.
hip hop, hooray. Don't forget about the HOA.
Very clever. Unfortunately, there's no super lien for HOAs. There's just nothing we can do about it. Well, I shouldn't say that. There's nothing we can do about it currently. Florida does have a limited super lien for HOAs, but that's just not what we're seeing in Mass, New Hampshire, Rhode Island, or Maine.
We don't even have a statute that
For
governs
HOAs, which is
HOAs.
really incredible. That is incredible. I mean, HOAs are governed by CC&Rs. So who knows? You buy into it or you're trying to manage it. It's impossible to figure out what's going on there. Now, we strongly urge that there be advocacy on the part of the New England states, because most HOAs, believe it or not, there is a lien that exists. The money that's owed is still a lien on the real estate, but there's nothing you can do about it until you get to the resale situation. And I had a case a couple of years ago where the attorney for it was interesting because the the homeowner was the developer. And he said that it didn't apply, not because he was the developer, but he had some crazy arguments about how the restriction that he wrote had expired, even though we had writing because he changed the name and done all those things that developers do. So ultimately, we won that, but it was like, where's the statute when you need it? You have to make sure that your declaration does use the word lien, though. You can't just say, well, the lien exists the way we do in Massachusetts because of the recording of the master deed. As Ed said, there is no statute to help you. So if your declaration doesn't have the magic word lien, you can't lien. Maybe you can sit, but you can't lien.
I mean, we don't have a lot of HOAs in New England, but we have, I mean, it's not like Arizona.
No, but we do have a lot. We do have a lot of them. And I think they're getting more popular. I've seen a lot of them coming online lately. So the first thing I do when I get one of them is I flip it open to see if there's a lien language.
Have you ever seen any that have priority lien language or language that sort of tracks 183A Section 6?
Not in an HOA, not yet. And it doesn't make sense to me, frankly, because it would be such an easy thing to do.
I've seen one. I've seen one that actually had, it said the collection process shall be
in accordance with 183A.
Yes, and that they'll have the same rights as a condo would under the act.
Well, that's something we should all be advocating for, and definitely statute, definitely. It's just mind boggling. There's a statute for timeshares, there's a statute for mobile homes, there's a statute for condominiums. Hello, what about HOAs?
I think in Massachusetts, over the last couple of years, there has been a statute that's been proposed, but it just hasn't gotten
It didn't
through.
get any traction. So, HOAs have these CC&Rs that I refer to, covenants, conditions, and restrictions. Arguments do arise sometimes about the restrictions. They've expired. So people say, well, they've expired, we don't have to pay anymore. Well, that's not true, because these are what we call covenants that run with the land, and they don't expire. So maybe your personal obligation to pay expired, okay, but again, it's a covenant that runs with the land, and we're going to collect it on the other end when you go to sell. Interestingly, I have found, I'm always amazed when I have one of these cases and the board will come to me and say, well, what should we do? The bank wants a 6D, because the bank is actually asking, the bank doesn't understand, they want a 6D. So we do a, not 6D, a resale certificate, and that's what happens with it. So it's such a funny duck. It walks like a duck, like you said, but it's not a duck. So this is one of those instances where it's not a duck. The covenant to pay is different than a lien. It's an equitable situation, and it is on the land, and we've got that lovely language that it runs with the land. So it's there.
I believe it's the Sullivan case that says, and Ellen hinted at it, the HOAs have, sometimes they expire. They have like deadlines as to when their restrictions go away. That is the restriction that says you can't paint your house pink or whatever. But the Sullivan case
to pay says, Sullivan said, absolutely you have to pay.
You absolutely have to pay. You may no longer be restricted to paint your house pink, but you have to pay.
But the situation came up in Sullivan as to the personal liability.
Yeah.
That's a whole other issue. So the bottom line is that you want to see if you can get language in your declaration, and some declarations can be, I mean, they can be amended. They generally are more difficult to amend than condominium documents, because they have, almost all of them have, I think the ones I'm familiar with have 75%. You don't even have 51% for any of them, but you try that, keep working with organizations to advocate for proper statutes to protect them. And fortunately, we haven't seen HOAs going under like we did with condominiums for failure to pay. But it still isn't fair. It isn't the amount of money we're talking about. It's the basic fairness to everybody else. Ed, would you like to talk about 6 feet apart and all the stuff that came out of the pandemic?
So our number one hit, surprisingly, given that we're 2022, is 6 feet apart. And sort of what I like to call the pandemic effect on collections. And what I like to tell, because I'm the guy that winds up litigating the cases when they go to court. And what I like to tell clients is, even though you've heard us at the beginning say that we have the strongest super lien, we have blood and prints, we have all of this strong law in Massachusetts, is that there is no such thing as a slam dunk. Even when the law is strong, the facts can sometimes be stronger. And I like to, advise my clients, don't give the judge a reason to deviate from or ignore the law. And I think that's important for what we all do collectively. The law is so strong when it comes to this thing. Please resist the temptation to bring bad cases in front of the courts, because then all we wind up doing is eroding all of that good law that we have established over the last 20 years. Condominiums are under enough scrutiny as it is. We all know what happened down in Florida with a condominium collapse. We like to stay off the news. What did we see during the pandemic? We saw eviction and foreclosure moratoriums, people getting used to or trying to get used to not having to pay, elongated processes for lenders, for landlords to collect the money that should be paid under their lease obligations or their mortgage obligations. Fortunately, sigh of relief, we did not have that same sort of
Scrutiny.
Scrutiny or moratorium placed on us. Let's not give the legislature a reason to regulate condos. Let's not give judges a reason to deviate from the law. I mean, if you think about, again, it's not collections, but if you think about Florida, where at that condo that collapsed, a bunch of people said, we didn't want to pay our fees. We didn't want our fees to go up. And now, building collapses. And now we have legislatures looking at, imposing certain restrictions, legislative requirements on associations to ensure that doesn't happen again. I do continue to see in court from the pandemic, still a little bit of a trending toward a new empathy for debtors. We've got a whole new slew of judges that have come in as a result of retirements over the last couple of years. And, my takeaway on this is just always keep in the back of your mind the context of what you are pursuing. And how might this, we want to get that $50 or that $1,000, but are our facts good? Or are we just trying to pile onto what is strong law? Are we doing the right thing? And if we do the wrong thing, could it ultimately have drastic consequences the next time we have a real case? Could it have drastic consequences for all condominiums, all property managers, all attorneys that practice in this area? Practicing in this area can be tough enough. Let's not make it more difficult for ourselves. So with that, we're going to give you one last track. This is going to be our bonus track. And this is remedy. And we think this is important to talk about because it's alternative collection remedies. Ellen.
We already had a question on termination of services. Can you terminate services? Somebody wanted to know if you can not snowplow, if it's snowing, if you can just leave them plowed in, unplowed rather. And the answer to that is no. You can't suspend providing services except in New Hampshire, which allows it. And I happen to think that's a great thing. If you haven't paid for it, why do you get it? It's very sensible. And you can amend your documents.
Yeah, I was going to ask that, Ellen. So if it's not New Hampshire, can you amend your documents to provide for?
Absolutely. For sanctions, for not paying your common fees, anything from you can't run for the board to taking away. No, I wouldn't say that you can do, and I think New Hampshire allows some of this, but I don't know New Hampshire law. I leave that to Ed, but I wouldn't suggest taking away anything that leads to health. I wouldn't suggest if you have a central system that you turn off the heat in the unit or something like that. I just had an issue where at a condo where a unit was leaking and the unit owner wouldn't fix it. And the board said, well, we're going to turn off his water. I said, no, you can't do that. That's not a good idea. But you certainly can prohibit them from using the pool, the gym, the clubhouse, don't plow, things like that. I have no problem with you amending the documents to say that, because again, it's fairness. Why do you get to use something without paying for it? So that's, to me, an easy fix.
Nothing worse than not being allowed to use the swimming pool. The one I've seen a lot, and the amenities in New Hampshire, believe it or not, is in some cases, it relates even to the parking. So if you've got like exterior parking lot or
You
parking
can
spaces.
prevent them from parking the space, right?
Yeah,
Yeah.
yeah. And believe me, that gets the bill paid. The other one I've seen maybe more in Massachusetts and Rhode Island is the suspension of voting rights.
Oh, yeah.
And people showing up at the election trying
With money,
to
with cash.
with cash, trying to pay, and then I have to point out to them, oh no, you had to be current
Correct.
7 days ago.
Right.
And boy, people get burned if they can't vote.
Or run for office.
Yeah. Yes.
Right.
Yes.
And the other thing is, sort of related back to fair debt, boards always say, well, this unit owner, if you don't have that provision, he's running for the board and he's owes, 4 months of common fees. Can we tell everybody that before the vote? I said, no, don't do that. Again, you're violating, not that the board would be liable for fair debt. I don't think so. And we haven't seen that happen yet. And I think court will be hard pressed under that circumstance. But nevertheless, you don't go standing up in front of everybody saying, oh, so-and-so is running for the board and, he's an accountant and he's been an accountant for 32 years. And by the way, hasn't paid his common fees. Not a good idea.
I remember years ago, there was an association that I represented. I think I went there for a meeting and they had the names of people that were delinquent on a bulletin board. I told them to take that thing down because you have other remedies. You have other remedies, and you do something like that, you're likely to wind up hurting yourself and possibly getting sued.
Now, we have what we call in Massachusetts a split lien. The unit owner is personally liable. And as I said to you, we've got that lovely little fiction that the unit is also liable, but that's for the fact that's because it's secured by the unit. We will very often get a judgment for everything. When we go to court, we get a judgment for everything, but we know that the priority portion is what the bank is going to pay. So what do you do with the rest of it? It's a personal liability. The unit owner still owes it. If you know that the unit owner has a Rolls Royce that doesn't have a mortgage or doesn't have a loan or whatever, and isn't in a corporate name and is the unit owners, you could really bring suit on that and attach that asset and sell that asset to satisfy. That's the personal liability. Do you want to bring a unit owner into court, into supplementary process and examine them for the ability to pay that debt and then have them pay $10 a month for the rest of their natural life? Maybe some associations want to do that for the personal liability. We have never found it to be particularly successful. We don't have a lot of unit owners who have Rolls Royces parked in the garage and don't have a car loan. But it is available if the board wants to go after somebody on personal liability. And I know that sometimes boards want to do it because they've gotten the priority lien from the bank. There's all this other money sitting there in fines, et cetera, and so forth. And yes, the unit owner owes it. And then they see the unit owner having the kitchen redone and they get really aggravated. And I understand that. So it's one of those, like Ed said, bad facts make bad law. Do you really want to go through all this? And next thing you know, the I-team has it and it's on the news that you're pursuing this poor unit owner, and condos get such a bad rap anyway. Whenever there's publicity, it's never about anything good a condominium does. It's always the poor unit owner has a leak, whatever. So it exists, it's there. We don't recommend doing anything with it, but it is available to you. I mentioned earlier 6D certificates. I know boards say, but we want the money now. We had to lay out the money to fix this. We want the money now. It's not a perfect world, but the perfect part of this is, well, you might not be the board then, but future board will get that money and it will ultimately go back to the association who incurred the debt to pay for his misconduct. So ultimately you get it. That's
and sometimes
the 6D.
And a lot of times, at least in the last several years when we were going through the refi boom, obviously the lenders need a 6D certificate when you do a refinance. So So these non-priority amounts
We're getting paid.
we're getting paid when owners were deciding to refi, because we would give us what's called a dirty 6D
36D.
certificate, which would identify the amount of the non-priority amounts, the fines, or the misconduct, or the chargeback, as some of the folks.
But you know what what I found interesting? Lately, in looking at titles, I've been seeing a lot of refinances where they didn't ask for a 6D.
Isn't that interesting?
Yeah, it's slipping through the cracks, and it's like, oh, well, we just
Wow.
go forward. Yeah,
Well,
yeah. So.
well, I think that takes us, we're through the bonus track. That takes us to the end. Ellen, what would you say your number one piece of advice is, your number one takeaway to everybody that's been patient with us today to listen for the last hour and a half?
Well, the risk of being self-serving, send us your debtors. I mean, but the number one piece of advice is, this is going to sound awful, don't be nice. I mean, just don't. It's very, very rare that there's a reason for somebody to be allowed to be in arrears. And it's hard when somebody gives you a real legitimate sob story, but you just have to enforce and use the tools that you have. And remember that you're there for the good of, you're representing the association or managing the association, and not for that one person. So that's the best I can come up with when Ed asks a question that I wasn't.
Yeah,
prepared for.
I think mine is.
See, he has a better answer.
No, I don't think I do. I just think, look, you understand, if you're a board member or if you're the manager and you're acting on behalf of the board, you do have that responsibility to the association as a whole. And that includes collecting, because that's your only source of income. That's how you pay the fees. My takeaway is, all the stuff we talked about, all the tricks, traps, nuances, bankruptcies, all that stuff. It's when someone's more than 60 days, they're 2 months behind, send it to the lawyer and let the lawyer that's had to deal with this and understand and learn all of this for the last, 20 or 30 years of practice in multiple states. Let us work through it. When you get that bankruptcy notice, send it to us. Let us work through it. Let us protect you. Let us make you look good, and ultimately you make the association look good. So,
and it's really a win-win, because we get the legal fees paid. It doesn't become a line item on the association's budget. So it's really a win-win for the association.
all right. Well, thank you everybody for bearing with us for the last 90 minutes.
I have one question here that I didn't answer, and I hit the wrong button, so I don't want this person to feel ignored.
Go ahead, Ellen.
If the board issues a special assessment, can that be paid over time? Yes, that's up to the board to make that decision. Is there a limit to the number of months over which a special assessment can be paid? I've seen special assessments that have been stretched out over a couple of years, when it's, a very hefty one. So there's no limit. But when you're talking about one that's going on for, I would say, more than a few months, you really, really, really should be amending your budget and not carrying it as a special or supplemental or whatever you want to call it. Just, it's so much neater and cleaner. And I know there are issues I've heard people say, but it's a question my accountant wants to know, and taxes and capital gain and yada, yada, yada. At the end of the day, you bought a condominium. You're going to have to live and die by how the condominium operates. And carrying a special assessment on your books for so long is almost a red flag to a lender. So that's my issue with that question. And I don't think we have any others that we haven't answered.
So I wanted to thank everybody again for bearing with us. Like I said, we tried to keep it interesting with the music, and got a lot of fun and colorful responses from folks, either privately or in the chat, in terms of guessing who the artists were. Now, when we finish, I'm gonna take the names of the attendees. I'm gonna put them in a hat. And like I said, I got 2 Celtics tickets on Monday, November 13th. They're playing Oklahoma City. Decent seats, like about 19 rows back in the loge. So I will do that and send out notice to the winner later this afternoon. Thank you, folks. We really appreciate you bearing with us. Oh, and if anybody needs the slides or wants a recording, some of you have already asked for it. Shoot me an email, shoot Ellen an email, and we'll get that out to you.
Thanks a lot. And everybody have a good weekend. And we hope to see you at future webinars.
Thank you, everybody.